Good evening, everybody, and welcome to another Killick & Co webinar. We've got Demystifying Estate Planning. I'm your host for this evening, William Stevens, Head of Financial Planning. I'm joined this evening by my colleagues, Shaun, Robson, Head of Wealth Planning, Sarah Hollowell, who's our Director of Tax and Trustee Services, and Senior Wealth Planner, Arica Gourlay. And this evening, we're going to be talking through what are the essentials behind estate planning and what are some strategies that individuals can introduce to try and mitigate inheritance tax. This webinar is broadly accessible to anyone, but particularly those who are looking to get a grasp on how to manage their estate or manage the estate of their loved ones. We're going to cover quite a lot this evening. We're going to get started with some essentials for everyone, and then move into some more bespoke solutions for those who are potentially looking for ways to mitigate inheritance tax over the long term. There was a lot of noise about inheritance tax ahead of the autumn statement last week, and we almost had to rewrite the script entirely for this evening. But fortunately, we're here today to present on things as they stand. It's important to stay up to date with these changes, and we want to make sure that everything we do stays under review. So a lot of the content that we're going to talk through this evening is relevant for how legislation stands today, but legislation is, of course, always open to change. We're going to talk for about 15 to 20 minutes, perhaps, on a variety of strategies before we move into a bit of a recap towards the end, and then open it up to a Q&A. So if we've had some questions submitted ahead of time, if you do have more questions as we move through the presentation, please do issue them in the Q&A box, which you can find at the bottom of the screen, and we'll try and get around to those at the end. As always, when it does come to the Q&A section, we will be limited to answering what we can from broad-based situations, and anything that relates to, I guess, a more personalised circumstance. Please submit the question anyway, but we might need to follow up with you directly rather than answering it on today's call. So without further ado, we will jump into a bit of a starter on the essentials for anyone who's looking to organise an estate. So Sarah, perhaps I can start with you. You want to just talk us through the fundamentals? What are the real basics that everyone should be looking to get in place when they're looking at estate planning?
Okay, thanks, Will. Of course, before you even consider estate planning, you have to make sure that you've got a will in place to make sure that your estate goes to those that you want it to. But there are other things that you should also consider, perhaps at the same time as making your will, and these should all be put in order before you consider any sort of planning at all. So firstly, make sure you know exactly what your will covers. If you have pensions or life policies, or if your estate would receive a death in service payment from your employer, your will wouldn't cover those. So you should check with providers that you've got an up-to-date nomination of beneficiary forms in place. And then if you've got assets outside the UK, you might need to consider whether it's necessary to make another will in that jurisdiction, or you could look into whether your UK will might cover those assets. And then something that a lot of people overlook is if you've got assets that are owned jointly, such as your home or bank accounts, these aren't dealt with by your will. They automatically pass to the survivor when one of you dies. So once you've made that will, you should make sure it's reviewed every time your circumstances change. And sometimes if your beneficiary circumstances change, you might want to even things up a bit, perhaps for different children. And if you don't have a will, then the rules of intestacy will apply. And this is a very strict order of who will benefit from your estate. It starts with your spouse, then children, and sometimes intestacy can mean a person's estate can go up a generation to parents, which is something that most people want to avoid. And if you've got somebody who's unmarried or has no children, their estate might end up in the hands of distant relatives, whereas if they'd made a will, their close friends or a favourite charity might benefit instead. And intestacy, as well as applying to the whole estate, can also apply to a part of a will if that part of the will fails. So you might have a beneficiary or an appointed executor who dies before you do. And if you have a well-worded will that's been written up by a professional, they'll help to encourage you to avoid that by perhaps having a disaster clause in your will, so that any beneficiary who dies before you, their share will go to somebody else or to a charity. I'd briefly mentioned an unmarried person, so perhaps I should also state that where you have got an unmarried couple who also aren't in a civil partnership. If they haven't made wills, the survivor could receive absolutely nothing under intestacy rules, and there could also be inheritance tax implications of not being married.
It sounds like there's a reasonable amount to consider there before we even get started on the more complex nature of wills, Sarah, but I think a key part there is making sure that they're in place and up to date. You mentioned on the way through their executors.
Yeah.
I think this is something that frequently people perhaps underplay the importance of choosing. So from your perspective, you and your team have dealt with a lot of estates over the years. How should people think about the choice of executors?
It's a really sensitive topic, really, because the natural choice for most people will be to appoint your spouse or partner, if you have one, because they might already know the size and value of your estate, have a relationship with your beneficiaries, and they'll generally have a good understanding of your wishes. But when you die, they might themselves be elderly or vulnerable, perhaps because they're grieving, and they really might find it difficult to cope with tasks such as dealing with banks or utility providers. So perhaps give some thought to appointing someone from a different generation to act as your executor. You can have more than one, so you might want to have a child as well as your spouse, or a professional. A professional, in my opinion, can be a really good choice for a number of reasons. They'll obviously understand the legal side of applying for probate, the tax obligations of the estate, and because they're completely objective, they'll be able to deal with any family disputes or conflict that might arise. They obviously will charge a fee for their service, but it can give peace of mind that your estate is going to be dealt with without giving a burden to your loved ones.
And I think that's going to be a recurring feature for this evening, burden to loved ones. It's a difficult time in anyone's life. And I think the whole aim of this evening, hopefully, is to provide a bit more guidance to individuals on how they can almost simplify that or streamline that or make sure that their wishes are followed. The next thing that I guess a lot of people don't necessarily think about in terms of estate planning is a form of living will, in the form of a lasting power of attorney. Do you mind giving us a quick explanation on that as well, Sarah? It's a bit of a lesser known element of personal finance.
Sure. Well, while everybody appreciates that they're going to die at some point, and so they will even if they never get round to it, they'll consider writing a will, and they'll look at estate planning to minimise problems for tax or for their families. A lot of people overlook what might happen if they lose the ability to look after their own affairs. And it can be a really sensitive topic to bring up with parents or grandparents. So we'd always suggest that it's a good idea to give it consideration as early as possible. So there's two types of lasting power of attorney, one for property and affairs and the other one for health and welfare. So you should think very carefully about who you would like to look after matters for you. And you might find that you have one set of attorneys for financial matters and another set of attorneys for health related decisions. Someone who knows you really well could help with the health side, and maybe a professional for the financial side, or it could still be someone in your family. And then the LPA itself is a declaration of who you want to act for you. You have to have a certificate provider, which is somebody who knows you really well, and they're basically just doing a declaration that you know what you know and understand what you're doing. And then once that has all been registered with the Office of the Public Guardian, attorneys can act together or they can act separately, and they can step in and act for you either just if you lose capacity now or now and when you lose capacity. And once registered, many LPAs are never used because the donor retains capacity, but it's a really, really good insurance to have just in case.
Absolutely. You always want to make sure that the worst case scenario is covered off. As morbid as that may be to think about, but it puts your family and your beneficiaries in a better position should the worst happen. I'll quickly recap what I took away as your three key points there, Sarah. First one, make sure you've got a will and that it's up to date. And that anything that's not covered within the will also has something to accompany that from a legal perspective. Second one, think carefully about your choice of executors. Make sure that they're individuals who are going to be able to cope with the burden at the time when they're needed to. And thirdly, to look at making sure that people have got a lasting power of attorney in place to keep their estate well managed should they need someone to during their lifetime if they're unable to.
Yeah.
Perfect. Okay. Well, with a sort of brief overview of all the things people need to look at to begin with as a foundation of getting into planning for their estate, we'll move on to what I think probably most people are here to listen to today, which is a bit more of a discussion on inheritance tax. So we're going to set the scene on, I guess, how we think about it, how it works, making sure that we understand what's in scope, what might be outside of scope, and then begin to talk through a few strategies that can be deployed in order to manage that. So on that, I will pass over to my colleague, Shaun. Shaun, why don't you talk us through inheritance tax as a bit of an overview, so that we can understand how it works, and really get into the details of it.
Yeah, great. Thank you, Will. And I think as a starting point, just reflecting on Sarah's commentary, I think by formulating the essentials of a good estate plan that Sarah's outlined, you really lay the foundations for considering who and what is most important to you and how you would like them to benefit from your estate, both during your lifetime and on death. A good estate plan will help achieve two goals that I think most of us have. Firstly, how to live well for the rest of your life, and secondly, how to leave a good legacy. Now, a sensible starting point to establish a clear overview of your assets, and then you overlay an assessment of which assets do you need to keep to provide the income and capital that you need for the rest of your life. And I think by establishing your overall asset base, you can quickly calculate if the size of your estate may well lead to an inheritance tax bill on death. It will also help establish if you have assets that you don't necessarily need to rely on yourself and could potentially give away to people and causes close to you. Now, Arica will talk more on how we use cash flow planning to help our clients navigate this sort of balancing act between maintaining sufficient income for the rest of your lifetime and capital that you may need to call on in the future, with trying to mitigate the potential inheritance tax liability. And I'll start by providing a brief overview of inheritance tax and I think the impact that it can have for your beneficiaries on death. So inheritance tax, IHT for short, you'll hear us talking about IHT a lot this evening, is effectively a tax on the estate of somebody who's died. And the estate will include all property, belongings, and money, fundamentally. Now, we have an example of the impact of inheritance tax on an estate. And in this example, we're including, the estate will include things like the family home, savings, investments, personal property, including things like the family car. It's worth taking time when you're looking at your overall asset base to consider which of your assets are actually in scope of IHT and which aren't. And as an example, in this scenario, the pension is an asset that, whilst is owned by you, it falls outside of the estate for IHT due to the specific pension rules that exist. Now, there are other examples of assets that aren't in scope of inheritance tax, and we'll cover a little bit more on these today. Now, looking at the impact of IHT, it can be significant. It is ordinarily charged at a rate of 40% on the amount you leave behind above the nil rate band when you die, and reduces the amount of inheritance that's available for your beneficiaries. Now, in our scenario here, we've got a total estate worth 2 million, and you'll see that there's a nil rate band and a residence nil rate band that are both available for this couple, available because their family home is passing to their direct descendants. Now, the combination of nil rate band and residence nil rate band means they are shielding £1 million from IHT. The pension itself, that's worth 250,000, is also outside the scope of IHT, and this leaves £750,000 worth of assets that would be charged at a rate of 40%, equivalent effectively to a tax bill of £300,000 on second death. Now, whilst our example is looking at an estate of £2 million, dropping to 1.75, given the pension is out of scope from the IHT net, it is worth noting that if your total estate exceeds £2 million, the additional residence nil rate band that we've noted starts to taper down by £1 for every £2 of estate value over 2 million, to a point where it will be completely lost if your overall estate is 2.7 million or more for a married couple. Now, whilst we're looking at the impact of IHT, we really want to focus on the potential solutions that exist to try and mitigate the impact of IHT over time. And I think a good starting point is to note that whilst there is no silver bullet to this challenge, and there is no one-size-fits-all solution to mitigating the IHT bill. There are certainly ways to reduce the impact of IHT on your estate over time, and we'll spend some time today exploring a number of those options that are available. By taking sensible, considered steps during your lifetime, really using tried and tested solutions that exist, you're able to shift the benefit from HMRC to your family and your beneficiaries over time. Now, people may consider estate planning and IHT mitigation as something to worry about and plan for much later in life, but our experience in helping clients navigate these challenges tells us that it's never too early to start thinking about putting an estate plan in place. Starting early really gives you the most flexibility of the options available to you, and will give you the best chance of ensuring your family inherit in the way, and importantly, I think at the time, that you would like them to.
Thanks, Shaun. I think that's a really good point there you've made on, ultimately, where does the money end up? And really a good estate plan is deciding where that money is going to end up and at what stage. And, I think the illustration we've got on screen currently shows that should you do nothing, there is, a significant probability that some of that money, or at least a significant portion of that money, may end up with HMRC rather than your intended beneficiaries. So on that, we could probably jump into how, I guess, we think about inheritance tax and how we go about formulating a financial plan to consider it, the advice we may provide to our clients. So, Arica, I could probably turn this illustration off for now, but
Great.
Why don't we move on to you?
Perfect. Thanks, Will. Well, look, as Shaun mentioned, the starting point for estate planning is, first of all, making sure you have enough to cover your own requirements. Now, he did mention that we also run a cash flow modeling exercise. So this is really about establishing a direction of travel, really. It's for your finances and giving you some visibility. Now, hopefully on your screen, you can see an example of a model we've built for a client. So this is a snapshot of their net asset picture. So you've got purple there, which represents property. We've got savings, investments in your pink and blue, and green represents pensions. So we factor in income, we've got your expenditure, future care costs, and we're forward predicting the asset picture over time. So using various assumptions on investment returns and factoring in inflation. So you can see in this scenario, this client is accumulating assets, and that's despite drawing from their capital. So if they don't take any action, they're going to have quite a significant inheritance tax bill. Now, first thing I would say, and we would say at Killick, is you've built this up over your lifetime. You've worked hard for it, so enjoy it, spend it. It's there to enjoy. However, we often do find that people don't change their spending habits. It can be difficult. So if we're not going to spend it, we may be thinking, what else can we do? Now, as Shaun mentioned, there are many planning opportunities for you, but this is a complex area of advice and there isn't a one-size-fits-all solution. So first of all, we have gifting. So if you're not going to use that money, think of others that can benefit, especially when it can make much more of an impact in their lives. Now, making lifetime gifts is probably the most common way to remove money from your estate. You've got your annual gift exemptions, which you should see on your screen there. So gifts within these allowances are immediately outside of the estate for inheritance tax purposes. So these allowances are per person as well. If you're a couple, you've got £6,000 annual gift exemption. If you don't use this exemption, we can carry forward to the next year. Gifting out of surplus income is another method for moving assets from your estate. Now, there are a few rules to qualify for this exemption. They must form part of your normal expenditure. It must be made out of income and also leave the donor with sufficient income to maintain their usual standard of living. Okay, so now anything over these limits does take 7 years for this to be effective for IHT planning, which means you would need to start thinking about gifting relatively early. Now, these gifts are also called potentially exempt transfers. So gifting can put clients off estate planning, and that's because it is irreversible. You've given that money away and you won't have access to that capital. Now, it's important to note, if you do gift, document this. So list the gifts, when and how. I'm not going to go into the tapering rules in detail, but if you're very generous and the gift exceeds your nil rate band, you may be eligible for taper relief as well. Now, this is just a lower percentage of inheritance tax payable if you don't survive that 7 years. Now, another option is a life insurance policy. And now this would help beneficiaries pay for an income tax liability. So it's great for clients who don't have a lot of illiquid assets. It's important to note, though, that it doesn't actually reduce the amount of inheritance tax due. It's just another way to pay the bill. So you also have to pay those insurance premiums throughout the lifetime, which can be costly. And it's important to note that if we do stop paying those premiums, the policy will lapse and you've just undone everything that you've tried to do. So as Shaun and Sarah mentioned, the other area is pensions. So your pensions is a major part of estate planning. Leaving your pensions to the next generation is effectively like a trust fund. So if you don't need this money, you still have access to it, so you can retain it, but you can pass this on to your loved ones. And just another thing to note, and Sarah mentioned this before, is just make sure you complete that nomination form. Okay, it's also dependent on what type of pension you have. So final salary schemes and annuities, they have less flexibility as well. So since we're on the topic of maintaining control and access to capital, so this is a good time for Shaun to step in and talk about some alternative options.
Thank you, Arica. And just to build on what Arica has explained in terms of potential solutions, beyond spending or gifting directly to beneficiaries during your lifetime, or perhaps ensuring the liability to create that liquidity on death, two further options we wanted to just explore very briefly. We're looking at potentially investments that are efficient from an IHT perspective, but also the use of trusts and the potential for gifting into trusts. So I'll just spend a few moments exploring both of these options. So if we focus on IHT efficient investments first, we've already discussed pensions and how efficient they can be in terms of building wealth that sits outside of the estate, and the benefits of maximising pensions during your lifetime for that very benefit, but still giving you access and control to them should you need to. There are other investments that qualify for business relief. So any entrepreneurs or anyone who's invested in unlisted companies perhaps in the past are likely to be familiar with the term business relief, which applies a rate of up to 100% on qualifying businesses. What this effectively means is that provided you have owned the assets for at least 2 years prior to death, they should qualify for an exemption to IHT, and therefore reduce the impact of IHT on death. Now, these types of investments are ordinarily deemed to be higher risk, smaller companies. So real consideration needs to be given to if they're the right type of investment for you. And we'd always advise that given the extra risk that they involve, only really a small portion of your overall investable assets should be allocated to this type of investment. But as an example, at Killick, we have an inheritance tax portfolio service, which manages a portfolio of small AIM-listed shares that qualify for business relief. Now, beyond the benefit of these business relief assets qualifying for an IHT relief after only 2 years, I think when you're looking at building an estate plan and an IHT mitigation strategy, it's looking at a blend of these different types of solutions. Now, the business relief assets really provide the ability to retain access and control to these investments that you may require access to them in the future, rather than necessarily having to give them away. Arica spent some time talking around different options for reducing the IHT bill by gifting assets away. Now, the downside of gifting assets away is that you've lost control and access to them in the future. So the real benefit of the business relief type investments is that, whilst you're holding them and you pass the 2 years, they will sit outside of the estate from an IHT point of view. The ability to be able to call back on them in the future and make sure you still have access to them can be really beneficial as part of an overall estate planning strategy. Now, moving on from investments that qualify for business relief, an area I wanted to touch on is trusts. And I think inheritance tax planning and trusts go really hand in hand, and probably a solution that many people have heard of and maybe be familiar with. So rather than making an outright gift directly to a beneficiary, this is looking at an alternative way of making gifts into trust. Now, trusts is a huge topic that we could probably spend the whole evening discussing. So tonight we just wanted to touch on, I think, the basic principles, just to highlight how they can be used as part of a wider estate plan. And if there is interest from the audience in hearing more on the topic of trusts in any detail, we'd be more than happy to consider that as one of our topics for future webinars, if there is the sort of interest from people to want to hear a bit more on trusts in particular. Now, trusts as a focus, they're a vehicle that must be set up with care if they are to be effective, and the right choice of trust will depend on factors such as how much control the donor or the settlor wants to retain over the assets that are placed into trust, and how much subsequent access they may or may not wish to have to those investments. Now, for example, a grandparent or a parent may want to set up a structure that will give a beneficiary such as a grandchild or child access to certain assets, perhaps at a set age, whether that's 25, 30, where normally legally they'll be entitled to those assets at age 18. And perhaps in the meantime, they wish for that trust to pay an income to another member of the family. The right sort of trust can achieve these aims, provided it's created properly. Now, there are trusts that allow settlors to hand over capital whilst keeping access to perhaps a fixed income stream for the rest of their lives. Or there are trusts that allow settlors to loan money into the trust rather than gifting it directly. That allows the growth on the investment to fall outside of the estate because the growth is captured within inside the trust. But it also allows the original loan to be recalled by the settlor should they need to access capital during their lifetime. Now, just that very brief run through, I think, highlights that there are various different approaches to trust planning, and they can really form a very useful vehicle for helping you mitigate the IHT liability, but there is real particular tax and administration implications about accessing and setting up trusts. So you really do need to take proper advice in terms of making sure that the trust is set up from outset with the objectives that you want it to achieve, to make sure that it's able to do so. I think just to wrap up on alternative solutions, beyond sort of business relief investments and trusts, it's worth just noting that what's the more these are typical sort of mainstream ways to deal with an inheritance tax liability, and perhaps for those that have exhausted these range of solutions or a combination of these solutions, some families may wish to consider more bespoke structures such as companies and partnerships. These can be a lot more complex and need to be created with care and the right type of advice, but using a suitably qualified tax advisor and solicitor alongside your sort of financial planner, they can work really quite well alongside the other solutions that we've discussed tonight and create lots of flexibility in terms of a broader estate plan.
Thank you, Shaun. Thank you, Arica. There's quite a lot to unpack there, so I might just recap a little bit on what we've just run through. So for everyone at home, priority number one, if you've got it, spend it. If you're not going to spend it within your lifetime, perhaps consider gifting it away, looking out for the relative allowances on the way through. And other alternatives include protecting it, getting some life insurance to cover the potential inheritance tax liability, investing into some inheritance tax efficient investments, those that qualify for business relief, such as AIM shares or smaller businesses and private businesses. And finally, the use of trusts, which, as Shaun says, we could probably go on for quite a period of time. So we will perhaps pick up that on a separate webinar if that would be of interest to people. So please do let us know via feedback if you would be interested in that. So we've gone through quite a lot, and I'm cognizant we want to leave time to get to questions. So we've got a lot of questions coming in, and we had a few ahead of time. But in terms of a quick recap, just work my way around the group and just get one key takeaway from each of you, if possible, or any other considerations that you think have been missed on the way through. So Sarah, we started with you, so let's start with you again. One key takeaway from you, what would it be?
I think the key takeaway would be to regularly review what you've got in place and make changes whenever your circumstances change, when your beneficiaries' circumstances change, and as Arica mentioned before, whenever legislation changes. And if you struggle to keep on top of legislative changes, then keep an eye on what we're doing, because we always like to keep our clients informed of what's been happening.
Perfect. Thank you. I think that's really important. Arica, we'll go to you next. One key takeaway from you.
Yeah, I think from my side, I think it's just important to note this is just, it's not a one size fits all area of advice. Everyone's needs are different, and it's quite a complex area to explore as well.
Indeed, there's a lot of changing and moving pieces on this one. And then finally, Shaun, one key takeaway from you, if Sarah and Arica haven't taken them already, what would you add to the mix?
Yeah, thanks, Will. I think I mentioned it during the presentation that for lots of us, we consider estate planning, planning around inheritance tax to be something that we will tackle later in life. And maybe it's something that we don't always get around to because it's thinking about things like death and taxes, which aren't the most exciting, and things we don't really want to consider planning for. But I think my biggest tip and advice, and I guess key takeaway would be it's never too early to start planning. By doing so, you will absolutely give yourself more options and the best chance of ensuring that your estate passes as you want it to, when you want it to, during your lifetime and on death. So yeah, it's never too early to start planning.
Absolutely, never leave it to the day to death. Maybe try and get ahead of that. Make sure that you get to enjoy watching your beneficiaries enjoy any gifts that are being made to them as well. So thank you for that. We'll open it up to the Q&A in just a second. In the meantime, what I wanted to say is we're going to put a poll on screen now. Just a quick poll for those who have been listening today who would like some specific follow-up from one of our wealth planners, financial planners here at Killick & Co to discuss any of their individual circumstances and how they might be affected by the issues we've discussed today. We have got a specialist team of advisors here who cover this on a day-to-day basis, and so they're in a position to provide you with any advice you may need. Beyond that, we'll move into today's Q&A. We've got a lot of questions in advance and a lot in the chat as we've been working our way through, so thank you very much for the engagement in today's session. We're going to get started. We've got one that came in earlier on the emails, so Arica, perhaps you could cover this one. What changes are there in the way in which an estate is taxed if one dies prior to the age of 75 or after the age of 75? Particularly if we're thinking about pensions here or any other tax efficient investments they may hold.
Yeah, sure. Thanks, Will. So the death benefits of pensions actually changed before the age of 75. If something happens, they can be passed on to the beneficiaries completely free of tax. After the age of 75, it's taxable at their marginal tax rate. With changes ahead as well, this is likely to be a lot different from April next year. So we can cover that in a future webinar.
Perfect. Thank you. And then we've had quite a few questions have come through early, a few about control and a few about timing. So let's jump into one on control, perhaps maybe one for you, Sarah, as our head of tax and trustee services. We've got the question here from a client who has an only daughter who is married with 2 children. What they want to do is ensure that their daughter and their grandchildren are the beneficiaries of the bulk of their assets. They want to, protect for potential implications from death or divorce. So are there any solutions that they particularly should be considering? Where does that sort of lead you in your thinking?
The simple answer that I can think of straight away would be a discretionary trust. Because with a discretionary trust, the trustees decide who payments go to and when. And because you don't have any one person who's absolutely entitled to any of the money, it isn't seen as their own asset if there is a divorce or a bankruptcy. And so it can protect against those. But discretionary trusts can also be really useful for protecting against any future beneficiaries who might be a bit more vulnerable than others. So if you're looking at a daughter who's got children, you don't really know what those children's circumstances are going to be as they get older. So a discretionary trust with a really carefully worded letter of wishes to accompany it, because that can help the trustees make decisions when it comes time to do so.
Excellent. Well, there's some work in there for your team, I'm sure, for that individual. So if they want to follow up, please get in touch afterwards. We've got a lot of questions here to do with potential inheritance tax on gifts. So Shaun, perhaps I can come to you on this one. A question on how the 7-year rule works, but also who would be liable for any inheritance tax on a gift that has been made if the 7 years haven't elapsed.
Yeah, sure. And I think Arica touched on sort of a general overview of the 7-year rule, which is effectively what we call potentially exempt transfers. So I think the key point here is that you can make gifts of any size you wish. There is no limit on the gifts that you're able to pass to your beneficiaries during their lifetime. It's absolutely uncapped. However, the taxman says that if you die within 7 years of making that gift, they will look to the size of the gift and would like to charge some level of inheritance tax depending on the size of the gift, and also any other available allowances you might have from your estate, i.e., as Arica mentioned, if that gift is below the nil rate band, effectively that gift would be treated as part of using up your nil rate band. However, if the gift goes beyond your nil rate band, then there's something which is called taper relief, which starts to kick in after a 3-year period and will reduce the size of the IHT liability that sits on the gift that's been made. And then the point around who is liable, it's effectively the beneficiary who has received the gift that would be liable for the inheritance tax bill that's attached to that gift.
Brilliant. Thank you, Shaun. So considering when you're making the gifts and what the implications may be to the individuals, I think we can agree is important there. You know, they need to make sure that if they have been made a gift and there is a risk that something may happen within 7 years, that they've got something in place to potentially pay for that IHT bill should it become due. We've had a lot of questions here on life insurance. Arica, you seem to have piqued some interest. A couple of questions, I'll throw them both at you at the same time, if that's okay. One of them is, where can you get it from? And the second one is, does it sit outside of the estate for inheritance tax?
So for protection, I mean, you can go directly to an insurance provider. However, we would recommend seeking financial advice just to make sure that you're setting this up correctly. Another thing to note is just ensuring that the policy is written into trust. So if it's not written into trust, it means that the policy could form part of the estate once it's paid out as a lump sum. So that's just so making sure there's a trust deed completed when you set up the protection policy, or even if it's set up already, you can complete a trust deed down the track as well.
Right, thank you. Questions on pensions. Shaun, I might fire a couple at you on this one. We've got one in the Q&A. What is the age limit of contributions into SIPs with a view to passing assets on from outside of your estate? And then I'll give you a follow-up to that when you're done with it.
Sure. Okay. Yeah, no, thank you. So age limit on contributions into SIPs. So principally, there is no age limit on making contributions to SIPs. However, the tax relief that you benefit from on making the gifts does change depending on your age. Now, up to age 75, we can all make contributions into a SIP and receive tax relief. The amount of contribution we can make and the tax relief that we receive will depend on our earnings and also the rate of tax that we pay on our income. But principally, you can make contributions and receive tax relief into your SIP. Beyond age 75, you can still contribute into a SIP, but you won't receive tax relief on the contribution. So that's the difference in terms of that age 75 point from a contribution.
Perfect, thank you. And then just quickly, I know we covered this in a webinar earlier in the year, but on pension contributions, is the limit to what you can pay into the pension your income in a year, or can you use it to offset capital gains tax as well?
Yep, so in terms of limits on pension contributions, there absolutely is a limit on how much you can add to a pension each year. It's called the annual allowance. Now, the annual allowance for this year is £60,000. However, depending on the level of income, it can taper down to 10,000. So really, the thing to note there is if your income starts to go above 200,000, you really need to make sure you're taking some advice to understand the impact of your total income and how that might interact with reducing your annual allowance. But principally, if your income from all sources is below 200,000, you certainly shouldn't have any concerns about tapering impacting you, and therefore you can contribute up to 60,000 in this tax year. And just whilst we're on the point of contributions to pensions, it's also worth noting that you can also look back over the last 3 tax years for a mechanism that's called carry forward, and you can carry forward any unused annual allowance from the previous 3 tax years and add them into your SIP in the current tax year.
Thank you very much for the summation. We've had a few questions on defined benefit and final salary pensions. I think we'll probably come back to you directly on those, as that's quite a complex area to cover in today. So we'll move on from there. We've had a few about property ownership as well. And Sarah, perhaps I can pass one in your direction. We've got one here. So if you have a second home, which you're considering allowing their adult children to live in rent-free, if they're still using that as a second home, we can add a bit, I don't know if this isn't the circumstance, but if we add a bit of colour to it for people at home, maybe they live in the north, they've got a flat in London, and they've got children use it, but they use it occasionally. Would that be considered a gift for the purpose of inheritance tax if they're not charging their children rent on that?
So they haven't actually given the property away, they're just letting their children live in it rent-free. That isn't a gift. They can do whatever they like with that property while they own it. Problems might arise if they make a gift, they still retain a benefit of. So if they still live in it sometimes, then that might be seen as a gift with reservation of benefit. But while you own a second property, you can do whatever you like with it while the ownership is still yours.
The great news for the children, no need for their parents to start charging them
rent.
No. We've got one here. We covered the residence nil rate band earlier, and Arica, perhaps I'll pass this one over to you. We've got if you are a single person with a main residence, can you still get the residence nil rate band on top of a residence, on top of the nil rate band itself?
Absolutely, you can. You just need to ensure that your property is passed on to direct descendants, so that could be children, grandchildren, etc. You're also still limited to that tapering as well. So once we get over that £2 million limit, you start to taper down, and you receive less of that residence nil rate band. Perfect.
We'll keep going for a bit longer because there are still a lot of questions in the chat to get through, and I'm struggling to keep up with them all. But Shaun, perhaps I'll fire one over to you. Can I gift a property into a trust?
Simple answer is you can. And I'll probably defer to Sarah just to give an overview of the complexities that might exist for someone wanting to consider gifting a property into trust. Because I think, as I mentioned in the brief overview of trusts, you really have to consider tax implications, administration implications, and the restrictions that you then may have on that asset.
Yeah, there's two main things to consider. The first is if there's only property in that trust, you're going to perhaps need to introduce some money as well, so that if there are any trust expenses, tax or anything like that, and the upkeep of the property, that's going to have to be met somehow. But I think that the main issue is if you gift a property into trust that you still want to live in, you're going to have to pay a market rent to the new owner of the trust. Otherwise, that would be looked at as not a real gift, and it could then fall back into your estate for IHT purposes. It is a complex area, and looking at the comments that we've received so far, I think there's definitely appetite for a separate webinar on trust. So I hope that answers it briefly.
That's indeed. Thank you. I think gone are the days of being able to get away with a peppercorn rent on a property that's been gifted away. HMRC don't look so kindly on that these days. Just while we're on that, there's a question here which I think is probably quite a good one, but lead us on to potentially deprivation of assets. So Shaun, come back to you because you got away lightly on that one and passed it off to Sarah. Could you talk about the implications of putting assets into trust, particularly if we're thinking about potential care fees in later life and the cost of meeting those.
Yeah, absolutely. And just looking at the principle of moving assets into trust, it's effectively moving assets outside of your own control remit, regardless of the thing I mentioned earlier, which is around certain trusts which allow you to retain perhaps access to income and capital. We're looking at here, I think, at trusts that will effectively remove the benefit of the asset entirely from your own estate, and how that might overlap with kind of access to sort of care costs and support in the future. You have to be really careful in terms of making sure that it's not deemed to be purposely depriving your estate of assets that would have ordinarily been able to be used to provide for that care costs. So I think some planning needs to be given to consider the impact that might have on kind of future potential care costs that will exist in the future.
Thank you very much. Couple more just quick ones before we close off. So we've got quick one here on business property relief or business relief for who wants to cover it. I think Arica, I might come your way on it. So just double checking that business relief assets are still included in the calculation for the £2 million for the purpose of calculating whether your residence nil rate band is tapered or not.
You're okay, Arica, I can jump in if you're on silent. Yeah, absolutely. Good, very good question. The point I made earlier about business relief assets, the real benefit of them is giving you access to them in the future should you need to use them, but still having them notionally sit outside of the estate because they qualify for an exemption. It's a very good question in relation to the tapering of the estate, because when you look at the overall value of the estate, those business relief assets still belong to you. They will still be part of your estate from the IHT calculation. So it's a really good question. That's something to be aware of when you're building your estate plan, is not to fall into the trap of, okay, I've got business relief investments that qualify for an IHT exemption, and assuming that they sit outside of the estate from an IHT calculation point of view, like pensions do. Now, they have similar benefits in terms of sitting outside of the estate, but for the calculation purposes, they have slightly different nuances.
Thank you, Shaun. And then we are going to, anyone whose questions we haven't got around to answering today, we are going to come back to you directly. We'll get members of the team to follow up with you over the coming days. So please don't feel that we're going to ignore the questions. We will come back to you with answers for this. Just two really quick ones for you, Sarah, I guess on the administration side, one of which is a privately written will adequate for the purpose of the legal document setting out your wishes? And then a second question, which is going to be, what is the burden of proof for gifts out of regular income?
Okay, so I'll answer the will question first. Personally, privately written will is absolutely fine as long as it meets all of the rules regarding correct execution. So it has to have been signed, and it has to be signed in front of 2 witnesses who are also present when you sign the will. They don't have to see the contents of the will. What they're witnessing isn't the will itself, it's your signature. So you don't have to have a professional draw it up. You can do it yourself. It can be written on anything as long as those execution rules are there. And the other question was regarding burden of proof. As long as you keep really good records, because HMRC will explore bank statements, and if they believe that either a gift has affected your standard of living or that it wasn't regular, there's no definition of what regular is. So you might want to give a gift monthly, or you might want to give it annually. So perhaps something in writing to that beneficiary to say, I plan to give you X amount each year, because if you only survive long enough to make one gift, HMRC might deem that that wasn't regular, but something in writing to say that that was your plan to do so every year. So just keeping really good records and making sure that your executors have got access to your bank statements and so on, so that you can clearly illustrate that your standard of living didn't decrease because of making these gifts.
Perfect. Well, thank you very much, Sarah. And thank you to Arica and Shaun as well. And thank you to everyone who joined us from home this evening. I hope you found the webinar helpful. As I said, if we didn't get around to your question, we certainly will come back to you and we will follow up. A lot of interest in trusts, so stay tuned. We will try and get a trust webinar in the diary for future. In the meantime, we're getting to the festive end of the year, so I wish you all a Merry Christmas. Enjoy the rest of your evening.